Okay, we are now moving to item 21 from the Community Development Agency. This is a review and possible action to implement recommendations regarding legal access requirements for building permits. This is a long-awaited session that involves both the discussion and we expect action relating to this vexing issue. We want to make sure that everybody in the room has an opportunity to speak today. So after the staff report, I'll be calling on participation, public participation. Would ask that each person who intends to speak try to limit their comments to 5 minutes each. And unlike previous sessions, which were study sessions where I gave a lot of latitude to speakers, this will actually be enforced. There will be a 5-minute limit, extended only if somebody else who intended to speak cedes their minutes to the speaker. So I'm hoping that people can bear that in mind and won't consider me overly harsh if I gavel the more loquacious of you after their time is up. That said, I believe we have a presentation.
Unfortunately, she's just walking in.
All right. We'll start with staff report and recommendations from Community Development Director Stephanie Moreno and Planning Director Bob Selman.
Good afternoon. I apologize. The issue before us today is to hopefully resolve, at least temporarily, the issue of legal access. As you know, it became an issue for the county back in 2006 when we were issued a legal opinion by County Counsel's Office that building permits required proof of legal access at time of application. It's been an ongoing issue. It's caused a lot of concern for property owners, realtors, people in the building trades. The board has had several study sessions on this issue without a clear consensus in all areas. Staff was directed to bring the issue to Planning Commission after meeting with stakeholders to try to resolve the issue. We were unable to get, as indicated in my memo, even close to where we needed to be to go to Planning Commission that would resolve all of the concerns. So instead, we're coming back with a request for an interim solution to amend the code, to make certain exemptions, and for the board to set up a committee to take a look at the remaining issues of concern and come back with a final resolution. As outlined in the staff report, we're asking for an amendment to Title 17 zoning of the Calaveras County Code. Currently, the language reads, each use of land or structure shall have legal access from the nearest public road. Such access shall be constructed to the standards of the Department of Public Works for the land use proposed. The proposed language is to change the code to read, each use of land or structure shall have legal access from the nearest public road as indicated by a recorded deed, parcel, or final map, or court order, or other documentation determined to meet this requirement by the Director of Community Development or his or her designee. The following are exempt from the requirement to show proof of access for a building permit. Permits to construct a primary or accessory single-family residential dwelling, including the respective attached or detached residential garage, and also including permits for a septic system or other improvements required in order to receive a certificate of occupancy. B is permits to remodel, repair, or replace an existing structure and improvement. C is permits for earthwork related to fire protection and site clearing operations, agriculture and livestock activities, erosion and sediment control, and drainage improvements. And D is permits for the construction of a new well. We believe that these particular changes to the board would allow us to move forward with what we believe the original intent is to allow people use of their property for residential purposes. Those issues that still remain, such as commercial operations on property that do not have legal access, could be investigated and researched by the committee and come back with more formal recommendations to the board. One option that the board has, because I know legal access is still a remaining concern for the Board of Supervisors, is to adopt the code amendments with a sunset clause. If they would like to do such a thing, to put something into place to give people time to put their building permits in place over a period of time. I think that's one of the concerns you've heard from the public, is that these shifts in interpretation are having impacts on them. That would take that concern into consideration. There is also, so that's relative to the code amendments. There's also a recommendation in here to allow us to accept building permit applications for plan check pending final adoption of the amendment to Title 17, which means we could start plan check for these people that have building permit applications that haven't been able to be accepted. Direct Public Works to compile a list of all former public roads that were removed from public maintenance but should still be available for public access, with the intent that the list be considered proof of legal access for parcels on listed roads for purposes of building permit issuance, only as there are no changes being recommended to Title 16 proof of legal access requirements for divisions. In other words, it's just for building permits, not for the, there's no proposals being changed for subdivisions and parcel maps. And the theory behind this one is that there are roads that have been abandoned by the state and or county that were intended for public use. And the abandonment of public maintenance didn't necessarily mean that the abandonment was supposed to construe to be for public use as well. In some cases, it created landlocked parcels. I can think of a couple of instances up on Highway 26 in District 2 where that's the case, where they did a realignment of State Highway 26, and by abandoning the road, they abandoned the access to the property as well, and I do not think that was the county's intention to do that. So this would provide a method of documenting those particular roads. It would come back to the board for final approval if the intent was indeed to leave public access in place. The fourth recommendation is to create an ad hoc legal access committee consisting of the following representation. Charge it with coming back to the board with recommendations on remaining legal access issues within 90 days. I've had individual input on this county, the recommendations for the county committee, and I'd like to change my recommendations so that it did not include Board of Supervisors members or Planning Commission members, and instead replace those 3 positions with 2 more at-large. So there'd be a total of 5 at-large representatives, which could be each picked by 1 district supervisor. So it would consist of the county surveyor, the planning director, an engineer or architect, as approved by the board, a board of realtor member, an at-large real estate agent, since not all are members of the board of realtors, 1 title insurance company representative, and 5 at-large public representatives. The specific charge of the committee would be to review the remaining legal access issues and come back to the Board of Supervisors within 90 days, either of creation of the committee or their first meeting, whichever you so choose, with recommendations on how to deal with those. And that is the extent of our recommendations.
Thank you. Any comments, Mr. Selman? Any questions from the board?
I just have a clarification. On some of those roads that have been abandoned, some of them were abandoned because the property owners in question wanted to take them over because they really didn't want public access outside of those people who had parcels along that road.
That would be why the research is essential, because in some cases the county may have abandoned both public use and public maintenance, and others may have abandoned only the public maintenance. So we would need to research to see which applied.
Okay.
Thank you. Okay, at this time I'd like to open this subject up for public comment. Again, we will have this use of this timing, which gives you actually 5 minutes and a couple of seconds.
Good afternoon. I just started right afternoon. Good afternoon. I'm Bill Schmidt from Mountain Ranch, and I'm passing out page, I guess that's 2-20 of the Calaveras County General Code adopted December 9th, 1996. I didn't know about this section until Diane Keene, thank you very much, suggested it might exist. The printing that's relevant to this issue is at the top of the page. Goal 2-15 is to protect the reasonable use of property in the county. The policy 2-15A, allow the construction of 1 single-family residence on each legally created parcel capable of supporting such use. Implementation Measure 2-15A-1, permit the construction of a single-family residence on each legally created parcel in the county when such use is permitted in the zoning district applied to the parcel. The parcel has a source of potable domestic water satisfying county requirements. The parcel has an approved method of sewage disposal, and no known health or safety hazards exist on the parcel. Now, this is a pretty simple sentence, and what it says to me is if there's a legally created parcel, you're allowed to build on it. Sort of end of story. And I didn't, I'm embarrassed that over the 19 months this issue's been a thorn in my side that we haven't, this has never come before you, but I think this is, trumps the whole deal. And as I understand it, the lawyers can correct me if I'm wrong, this is that the general plan dictates what the zoning code is supposed to say. It's the governing document. So if that's the case, this is fairly well stated, and I'll yield my 2.5 extra minutes to anybody else that needs them.
Thank you.
Good afternoon. My name is Chris Williams. I'm an attorney in San Andreas. I haven't been here in a while because I've been working on cases that have been coming to me on easements as a result of this policy you implemented 19 months ago. I wish I had said this, but I didn't. Emerson Ben did. Politics is the art of looking for trouble, finding it whether it exists or not, diagnosing it incorrectly, and applying the wrong remedy. I think this is another beautiful example of that on the county's part. Excuse the voice and this medicine I have in my mouth, but we have seen a series of actions taken by the county that have been red herrings, septic setback lines, failing septic systems. Here's another one. I got up and spoke with a lot of other people 19 months ago about this issue. We felt that this solution, I don't understand this shoot first and ask questions later. I mean, there are a lot of dead bodies out there. There are a lot of dead economic sectors in the economy. We don't need any more help like that. This, we said from the beginning, was unfair, arbitrary, illogical, that the county had a major role in creating the situation, and please don't do it. But it was done anyway. There's thousands of legal parcels that were created in this county. The county allowed it. The county accepted some subdivision maps while declining the easements. Not just for maintenance, but altogether. The county has been willing to accept tax revenues from parcels that were assumed to have access. 19 months ago, we don't have access. So, why is it unfair? Well, because people relied on the belief that they had legal parcels and they could build on them. Why is it unfair? Because it shifts all the economic leverage to the adjoining property owners. Oh, you want to build. You need an easement. Well, I'll give you an easement for $10,000, or I won't give you an easement at all. I think it probably also creates problems for the title companies who probably wrote title opinions at one time that said people had access, and all of a sudden it looks like they don't. So this is like so many issues I've seen in the last 2 years that come full circle. They don't ask how the policy got the way it was. They don't ask for a meeting of stakeholders before they implement it, even on an interim basis. They just do it. And that's what's happened here. Realtors have suffered, property owners have suffered, taxpayers have suffered. So I just would ask you to either go with the recommendation, or even better with what Mr. Schmidt said, is just get the words legal access out of there, like some of the other counties do. And you're worried about being sued by adjoining property owners? What about having everybody march into the assessor's office and ask for a downward assessment because they no longer have legal access? I don't know what would hurt you more. But I think it was a bad policy when it was implemented. It continues to be a bad policy, and it should be changed. Thanks.
My name is David White. I've been here before, spoke on this subject, and I asked a question twice here before, and several times to Mr. Thomas. He hates to see me coming. It's always been that if there's a law against something, it's on the books somewhere. I mean, this is pretty standard. I want to know where this code is that makes prescriptive easements illegal. Everybody keeps telling me I don't have legal access, but nobody can show me the code. And it seems to me that somebody got the cart ahead of the horse here and made an arbitrary decision to this board, who knowingly or unknowingly or willingly or unwillingly jumped on board for whatever reason. And you've stepped into it and you've stirred up quite a hornet's nest. And this morning I heard Mr. Tryon questioning the planning here about a contract that was signed by the Sheriff's Department, or negotiated by the Sheriff's Department, and you felt that this should come back to you before it was signed, and you should have final say. Well, I am suggesting that if your staff members are going to come up with these recommendations for policies, they have some legal standing or precedent for them to question what has been law for my case since 1923. And now I got somebody questioning me, and you gave me the alternative. What do I do? I got to go sue my neighbor to get a right of way. I've been getting along with my neighbor, this particular one's been there for 25 years, no problem. He went to sell his property here a while back. Well, this is my cue. Now I got a handle on him. I can get an easement. He would never give me an easement before. But now I go to him and I say, hey, I'm going to put less pendants on your property until you give me an easement. You can't sell it. Now I got a mad neighbor. And justly so. We didn't have a problem before. I've been traveling now that road all my life. I've never had a problem with a neighbor. But here we are. So I think that it would behoove the board to do a little closer questioning to some of your staff members before you take on their fights. Thank you.
Hi, my name is Darren Borgadolin, and I'm in the same situation. There's things I just can't quite understand. You guys say that the law says that in order to build a house, they have to show their easements going in. Well, I've got 6 neighbors going through my property, and they have been for years, and now they're suing me for easements across something when they have, some of them have one parcel or many parcels, and every one of their deeds has an easement leading to their property that's legal, that has never been developed, because the county has never made them do so. And now I got to go through litigation and probably end up having to come back into a situation where it all falls back into the lap of the county again. And I would like to know, is there such a list of roads that were abandoned and no longer taken care of by the county?
I don't know that one exists. We're attempting to find that information.
Because going through my background, the previous owner who I bought from was the original homesteader, had been in their family forever. And all of a sudden, and they weren't living on this property, and all of a sudden somebody starts carving a road through there and paving it. Well, they went back in the 90s into litigation, or maybe before the board, and the board decided it was their road, and somebody wrote a letter from this county to my neighbor telling him to quit paving and stay off that property. And now today, the county's telling me that road belongs to them. So from 8, 10 years ago, when they were telling our previous owner to stay off, the other neighbors to stay off our property because it was the previous owner's road and property, now it's stated that it belongs to the county. That sounds kind of fishy. But anyway, I'm in the same boat as these other people, that you guys let people cross somebody's property. If you're going to vote on this thing, it needs to be where their legal parcel has a legal access that they legally have to develop in order to do so. Thank you.
Thank you.
My name is Dean Borgadalen. I am talking about the same thing. We have a federal law that says there can be no taxation without representation. And if I'm paying the taxes and I'm not being represented, then that's breaking federal law. And I'm all for whoever buys a piece of property has their own deeded easement. Because using somebody else's property and not paying taxes and demanding a road on it is not fair to anybody. Thank you.
Thank you.
Joe Kelly. I'd like to volunteer to be one of the members at large if this turns out to be a committee, ad hoc committee. The county's term exempt invokes eminent domain on my property. Maybe Mr. Williams would represent me. The term legal access requires examples A, B, C, and D to meet all county ordinance requirements. For example, Title 12, Streets, Sidewalks, and Public Places, also known as County Road Standards. Chapter 8.10, Fire and Life Safety Regulations, and CAL FIRE regulations regarding width, road load capacity, canopy height, dead-end road, secondary access. The phrase in A, or other, and the phrase is, or other improvements required in order to receive a certificate of occupancy, gives county permission to do whatever necessary by the illegal access user at the underlying property owner's expense. Now, my issue, Oleoacre Road. Access is east off Railroad Flat Road, south of Banner Road. Now, my understanding is Oleoacre Road, when I did my parcel map, Mike Del Ordo, at the time I believe was on the Planning Commission, he went back and he researched it. That particular piece of property goes back and goes, I think, through the sheep ranch since World War II. My issue is not that fact the road is there as an easement purpose. But my issue is this. This access provides ingress and egress for 4 properties, 3 developed and 1 undeveloped. Now, during my parcel map, I'm not allowed to use it if I wanted to use that as an ingress and egress access for my property. I can't use it. The road width is 8 to 10 feet wide. That's a key. As somebody else said, oh, well, you want to pay for it. Well, it's 8 to 10 feet wide. The road has erosion problems, particularly at culvert sites. I have no idea of the residential construction dates of the 3 developed properties. On one of the properties, a barn was constructed between 2003 and 2005. Apparently there was no issue at that time of legal access. Oleoacres Road serves 4 properties. It is not a driveway. The county road ordinance defines it as a road. I believe the road would be required to be 18 foot wide, paved, with shoulders, and a minor to collector approach, also paved, on a road with restricted regulated access, without the concern of having to have approval for this access. During the rainy season of 2003 and 04, I found what remained of concrete bags that had been set on the road to slow or divert water from eroding the road at a culvert. A truck had run over them, causing the concrete to go into the water. At the time, I was in a stormwater pollution prevention plan with regional water. This caused me grave concern. At one time, I offered the property owners, with their attorney in attendance, a solution to the problem. The solution was a road over to Banner Road. It would have resolved a boundary line dispute, eliminated Oleo Acres Road, and produced access to Banner Road, which is a paved road. I know, I paved it. The question of who was paying for the road came up. I responded, we all are, proportionately. That was the end of that discussion. Oleo Acre Road leaves my property and enters BLM land, or Bureau of Land Management property. Years ago, according to BLM, they had no record of use request approval. So it's a secondary thing. Now it goes over to the federal government without permission to use. In your proposed language, I don't see any guarantee from the county to underlying landowners of protection from incremental width expansion of these illegal accesses, nor do I see a guarantee of protection from damage to the land, waterways, and trees caused by users of the county-condoned illegal accesses. The proposed language, A, B, C, and D, conflict with the first paragraph. Got to look at that one again. With the first paragraph of the proposed language. The proposed language A, B, C, and D will create new illegal accesses. Adoption of the proposed language will devalue property not subject to Proposition 8. This is an eminent domain lawsuit waiting to happen. The proposed language is not the solution. Leave the existing language and enforce it. Offer incentives to both parties to cure the problem. Thank you.
Thank you. Would anybody else like to address the board?
Hi, Diane King. I'm not sure if Bill quoted the, I think he was quoting a section out of the general plan that is earlier. The section that I feel that should apply is on page 232, goal 2-22, and that whole section. So you need to pull it up and make sure that you're complying with your current general plan. And one of the things that I will pull out, it says, it has a whole bunch of stuff here, but it says, and shall not be denied the issuance of a permit or approval to develop the real property with a single-family residence structure unless a specific written comment is made by a county public health or safety department, blah, blah, blah. You can look it up, but I encourage you to comply with your current general plan, and that would help. Thank you.
Thank you.
I'm Scott Burr from Mountain Ranch, and I just wanted to comment on a few of the things that have been brought up. The code for the general plan that the previous speaker just referred back to is pretty interesting. I'm surprised that hasn't come up before, or has it? No. So hopefully that might provide a nice, comfortable solution to the problem, although I'm sure there's other factors to consider. Secondarily, the proposal that was made by the Community Development Agency, I think is hopeful. I've got way too many hours and moments devoted to this topic, as I'm sure many people feel the same. And we were very hopeful that that solution would be one that everybody could live with. It's reasonable, I think, and it probably fixes 80 to 90% of the problems out there. And it makes provision for creative problem solving for the remaining 10 or 20%. Bottom line is, somebody's not going to be happy at some point, whatever the solution. But I don't think county policy should be based on one or two or a small handful of people's special interest. It should be based on what works best for the majority of people in the county. We just last week talked about economic development and looked at some numbers about the condition of the economy in the county. And it's in less than stellar shape and probably heading in a worse direction. And a big part of that is fueled by real estate development and by construction. And if you look, I meant to bring it and I forgot, but I printed out a graph of residential and land sales in the county from January 02 to current. And interestingly, the residential did what everybody would expect. It climbed up to about 2006 and then started heading downhill. The land sales went similar pattern up to 06 and then just dropped off a cliff and stayed there. And a lot of that is because of the difficulty that we're experiencing with issues such as the legal access, because people are afraid to buy a piece of property, or they're having a problem developing the one that they bought 10 years ago for their retirement. So I acknowledge that it's a difficult problem to solve, but I do think the needs of the many need to prevail in this case. And I guess that's all I have to say at this point. Thanks.
Thank you.
My name's Gary Zuka. A couple of years ago, I worked as part of a coalition of agricultural interests to redo the zoning codes in the county to allow expanded use in agricultural land. The exemptions I heard today looked like they would provide some exemptions for residential use, but I think it would have a serious negative effect if we did not allow people who live on RA or agricultural land to get permits to expand for agricultural use as well.
My name's Penny Mahaley. We live on the infamous Arola Road. As a result of this problem with the county, we've been attempting to negotiate with our neighbor. Thousands of dollars have been spent on both sides in attorney fees. We have come to a tentative agreement, but we are anxious to know, and this is probably a corollary to the problem in general, we're anxious to know that the width of road that width of easement that has been offered will allow us to use our land within the RA20 zoning. 2 or 3 property owners along the road have approached various departments in the county, and we're having a real problem finding out, assuming we got an easement of X number of feet wide, would we actually be able to use our land within the zoning area? And we need some help on that issue as well.
Ma'am, what you need to do is talk to the Public Works Department.
Okay.
And they will tell you, you will be required to meet a road standard. It will not be a driveway standard. There's too many parcels out there. But they will tell you exactly what the template for that road requirement is and what the right-of-way is. And for God's sakes, if you're negotiating a right-of-way, get the right width and give yourself a little extra.
Absolutely. That's what we're trying to do.
If you have a problem with determining what that is, then give me a call, and I would be happy to meet with Public Works and you or a committee of people from Arola Road and make sure we get the width and the requirements accurate.
I may take it up on
Okay,
that. Thanks.
thank you.
Would anybody else like to address the board on this subject?
Hi, my name's Bill Vieira. I'm with the Murray Creek Homeowners Association, and we have a concern out in our place. It's a small subdivision, 23 parcels out there. Beyond our subdivision, there's some large acreages that is coming up for sale. Now, one person had owned the entire area at one time, kept selling out parcels, has sold out a ranch division, sold out the subdivision, and in turn sold out his only access to those parcels. So, I'm saying that, we're not trying to landlock anybody, but there's no law saying that somebody cannot landlock themselves. And that's exactly what has happened out there. Now, again, I said we're a small subdivision. We have an average, if you take the national average of traffic per day, 7.5, I think it is. We have an average of 172 vehicles that travel in and out of our road. If this acreage, which amounts to about 383 acres beyond our subdivision, is allowed to build out there, we're looking at an additional 574 more vehicles on our private roads. Now, our subdivision, we're governed by a CCNR, not CSA or CSD type program. We are a CCNR. We own to the middle of the road. And we try and maintain our roads. It's maintained in a constant state of decay. So I know you folks have a lot to deal with and a lot of different areas to look at, but I would hope that you would consider our situation as well. Thank you.
Thank you. Other conversation? If there are no further comments from the public, I'd like to bring this back to staff. There were a number of different interpretations of law, and I would hope that county council or deputy county council might weigh in on some of those as we move to answering some of the questions that came up. We'll start with the CDA and move to county council where appropriate on that.
Okay, regarding speaker number 1, Bill Schmidt, he sent me the general plan section this morning. We took a look at it. I would reserve that for county council to respond to on whether or not that trumps the ordinances that the zoning ordinances that you've adopted. That's a legal issue.
All right. We do seem to have various statutes, titles, and now general plan weighing in on this, not all of which appear to be consistent. We also have an Attorney General's opinion, and I'm hoping that county council will help give us the relative weight of each of those and try to sort out some of the apparent contradictions.
Right. I just want to state into the record, this issue has relied upon county council's opinion on legal access from the very beginning. Relative to Speaker 2, Chris Williams, I find it interesting that he talks about red herrings. He has appeared in front of this board numerous times on behalf of his client, Ray Waller, the former chief building official, and indeed, I believe, has thrown out a few red herrings of his own over the course of time. I wanted to state for the record again that this legal access issue was created because the former chief building official failed to follow county code in application of the building permits. You've heard from a number of speakers today that talked about changing policies or adopting policies unilaterally. This is a case where a public official adopted a policy without coming to the board for approval of that policy. It ran counter to county code, and when it came to our attention through a legal opinion, we had no choice but to follow county code as opposed to the policy that had been implemented by the department previously. I would say it's a case of a policy being withdrawn after being given direction to the board rather than a new policy being in place, and I just want to address that. Relative to Speaker 3, property owner wants to know what the code is that prohibits prohibits prescriptive easement, indicates that recommendations for policy should have a code section, and that is indeed our practice, is that we refer to code in all implementation of policies. And the issue about prescriptive easement, I believe, has been answered by this board to the extent possible in previous study sessions, and I don't know if there's any additional enlightenment that is available for that issue.
Well, Mr. White asked, where is the code regarding legal access? And I hope that will also be part of the answer.
It's in Title 17.
Right.
It's in the staff report that is in front of you, and at that which I read at the beginning of my staff report.
I think the question was, where's the code that said prescriptive access is not legal
And that is the
access. That's a
issue
different issue
that County Council addressed, I think, previously.
A court has to quantify what the prescriptive access is, because it can be from almost nothing to a whole lot. So.
All right. Well, I would like some discussion under this item from County Council regarding prescriptive easements and what they are and aren't. There's a lot of, I've heard a whole lot of stories on this, and I think it's very important that we all be on the same page, at least have the same information in front of us, so that can occur shortly. I appreciate it.
Speaker 4 and 5, the two Mr. Borgadellans, have a civil lawsuit pending relative to legal access on what the county believes is a county road. I believe they represent the minority opinion that has cropped up occasionally in this whole debate, is that we should not be allowing people to trespass across property if they do not have legal access. And I think that's basically what they're saying, is that people should have to demonstrate legal access in pulling of permits. Mr. Kelly, relative to the members of the committee, I look forward to his volunteering for that role. It would be subject to board approval of who's going to sit on the committee. He said there was no issue of access in 2003 or 2005. I want to reiterate that's because a policy was put in place that was in conflict with county code. The county code was not enforced, and that's why no issue was apparent at the time. His recommendation relative to proposed language is not the problem. Leave the existing language in place. I'm not sure if that's a reference to the existing language that is in the county code or the existing. Okay, so the existing county code requires proof of legal access for every building permit. Regarding Ms. Keene, the section of the general plan 2-22 on page 232 talks about legal nonconforming uses, but if you read all the way through the section, it also talks about section 2-22C-1, when expansion of legal existing nonconforming uses is proposed, require the property owner to meet the development requirements of the zoning district at the time of the proposed expansion. Therefore, that, I believe, eliminates the inconsistency that was noted. Scott Burr, relative to the also reference of the general plan and also talked about this being an interim solution, I think that it's important to note that we are only proposing this as an interim solution. This has been a hardship for the county, and this is a bad time to continue this hardship. We believe that this is a good compromise to move forward. The ultimate decision would not come into place until such time as it comes back to the board for a final approval, but it allows us to move forward. It allows us to take some building permits in. It allows us to vet this more formally at the Planning Commission and come back to the board and hopefully come to a final determination on all of the issues.
And any comment on the reference to pre-1991 circumstances here? Parcels legally created before?
We already recognize the pre-1991 for the health and safety, I believe, on driveway standards. That would expand this to take it into account for existing roads. CDA concurs that existing roadways would be appropriately grandfathered in, which would eliminate some of these issues. Relative to legal access, again, that's a policy issue for the board. If they wish to eliminate the requirement, then it doesn't matter if it's pre or post 1991. Mr. Zuka, on the exemptions for the ag issues, Again, those are what we hope to come out of the committee, recommendations on and I believe he's referring to agribusiness issues, not agricultural issues. Agribusiness refers to the winery and other types of commercial uses on agriculturally zoned land. They are a hot button issue and one that deserves and needs additional discussion before the board makes a policy decision, I believe. I believe Supervisor Tryon answered the question on Speaker 10. Relative to Bill Vieira from Murray Creek Homeowners Association, the proposal as it stands would not affect the Homeowners Association. If somebody wanted to subdivide the large piece of property at the end of that road, they would have to provide legal access per our codes. If they want to pull one building permit for that big piece of property at the end of the road, then they would not have to provide legal access. But I think your concern, as I understand it, is the future development of that, and this proposal does not exempt them from that requirement, and no proposal that we would recommend would exempt them from that requirement. CDA firmly believes that all parcel maps and tentative subdivision maps have to provide legal access in order to further divide their property. I believe I answered all the questions.
Thank you. Questions from the board at this point?
Yeah, a couple issues you wanted county council to weigh.
Yes, I'm sorry, you're right. Could we have a report, hiding in the back, could we have a report, there are several things that have come up here. It includes definition in maybe some, but not all of its complexities of prescriptive access. The question of what statutes are informative to this process. There are also questions of whether we can deal with our own Title 17 and still be consistent with other matters pertaining to access, like road, question of the quality and nature of the road and level of service. I wonder whether you might give us a tutorial in that so that the further discussion can be so informed.
Sure. Janice Elliott, Assistant County Counsel. With respect to Mr. White's question, which I have heard him ask on several occasions, his question is, where is it in the codes that says prescriptive access is illegal? And that is not what the county is saying. Prescriptive access is a form of legal access. What the county is defining here or addressing is, when does prescriptive access become legal access for purposes of pulling a building permit, or as already defined in our subdivision ordinance for subdividing property. In our subdivision ordinance, we define prescriptive access as perfected by court order, meaning you may have prescriptive access, but until you go to court and get a court order that says you have that access and it's sufficient enough to subdivide your property, we cannot allow you to subdivide your property. As background to many of the questions that have come up, Title 17, as we've all read here, says legal access is required for any use of property. The UBC says that before you pull a building permit, you need to comply with the zoning code, which is Title 17. Legal access is not defined in Title 17, so prior practice was to rely on the buildings official's determination as to what was legal access. And it's my understanding that he relied primarily on roads that were either shown on assessor parcel maps or other forms of documentation. The issue didn't come up until Arola Road was brought to his attention, and a legal opinion was asked from our office as to what is required for a building permit. And that is when I put in writing that you need to comply with the zoning code to issue a building permit. It requires proof of legal access, but legal access is not defined, so I can't tell you what type of legal access you should be looking for a building permit. You need to go back to the board to determine what it is they want as proof of access for a building permit. That's how this all came to the board to start with. The purpose of having a perfected prescriptive access in our subdivision ordinance is that a prescriptive access is a factual issue that depends on historical use of access to a property. The general rule, and this is a very general rule, it's been defined by the courts and by statute also, is that you have to have an adverse use for over 5 years. That means that you have to use the access with the knowledge of the person who owns the underlying property, and they have to allow you to do it without stopping you, meaning it can't be by permission, it has to be basically hostile, adverse. The courts have further defined what that means. Generally, the scope of the prescriptive access is also defined by the historical use, meaning if you've driven out there for 20 years to feed your goats and you want to pull a building permit to build a house, your neighbor has the right to say, no, the only access you have is to go out and feed your goats. That is why this issue came to the board, to determine what type of legal access you want for purposes of pulling a building permit. With respect to the general plan, I don't have the second section, but from what I can tell, it's in the nonconforming use section, which is what I anticipated. Nonconforming uses are uses that are in existence at the time we make a change in the zoning code. Only the zoning code is where you have nonconforming uses. The law says that those uses can continue to exist even though we've changed the zoning ordinance, but you cannot increase your nonconforming use without complying with current law. The law also provides you to sunset nonconforming uses, although our particular zoning ordinance does not do that. With respect to the other general plan language, as I recall, I don't have it in front of me, there are 4 bullet points, and the bottom bullet point refers to health and safety hazard issues. Ultimately, the board is the interpreter of the general plan, but I believe that the ordinances that we've adopted in response to that all take into public policy, safety, and health hazard issues, which are up to the board to decide how they want to deal with Title 17. With respect to Chapter 810, Stephanie's correct. She referred to the pre-1991 exemption grandfathered in, and that is also my opinion that those would be grandfathered in. With respect to Title 12, road ordinances, there are several modification procedures in there, as well as other exemptions to the road ordinance that could or could not apply. I'm not familiar with any situation where that's been an issue lately. Also, with respect to Chapter 810, there are modification and waiver procedures in that section also that have certain standards that are set in there, and I do know we have given some of those over the last few years. I think that was all the questions.
The Attorney General's opinion? Do you
Yes.
have anything to say about that?
There is an Attorney General opinion that basically, this has to do with off-site road improvements, not legal access. The Attorney General opinion holds that if you have a map that predates 1991 and you want to come in and pull a building permit on a road that was existing in 1991, you are only exempt from Chapter 8.10 requirements if, in fact, that map had a condition of approval or otherwise addressed the issue that is currently addressed in the fire life safety regulations. I think that's a rather limited reading of the exemption in the actual statute that set forth that regulations needed to be adopted. It is Attorney General opinion, and the board's free to follow it. I think it is safe to say, though, that anything that pre-existed 1991 is exempt from 4290 and our fire life safety code regulations. Other than that, it would be an issue that we would need to address directly, either through another Attorney General opinion or other avenues.
Thank you. If you could indulge me for just a moment, I was remiss in not reading a letter that came in that the constituents wanted read into this record, and I was wondering whether you might comment on that after I complete its reading. It has to do with prescriptive easements, and just as a case study, I'd be interested in your thoughts. This is addressed to the supervisors regarding, they say, prescription easements. I guess we can medicate this as well. We purchased land several years ago in Railroad Flat in the central part of town behind Railroad Flat School. 3 months ago, a man bought the property next to ours. He has proceeded to place dirt in the driveway that accesses our home and has removed the address sign to our home. Our home is now landlocked. PG&E cannot read our meter now. The driveway to our home is on the edge of this neighbor's land and uses very little of his property. He has completely different driveway to his home on his property, so this driveway has no effect on him. We've used this driveway for the last 3.5 years. Prior to our usage, the previous owners had used this driveway since the early 1940s. This driveway has been used for more than 66 years. 3 years ago, a teenager had gone to this property behind the school and started a fire. Had the fire department not had access to the property through this driveway, the town of Railroad Flat would have burned to the ground, including Railroad Flat School. This is not an exaggeration and can be confirmed by fire officials. We're asking you to review the prescriptive easement rules and realize that there are needs of individuals in the community that are imperative in evaluating the needs of the county. How do you receive this, and is that a correct reading of prescriptive easements, or is that a misunderstanding?
Well, I would presume, I'm not familiar with that particular property, but it sounds as though they have to access across somebody else's property to get to the public road, and based on the historical use, they more than likely do have prescriptive access. That's a prime example of where, even though you think you have prescriptive access, anybody can block you off until you have it perfected by court order. What the county does or does not do cannot create or perfect prescriptive access. Only a court can do that.
I'd like to stress that, because Mr. White has in the past asked the question, why doesn't the county recognize the legal doctrine of prescriptive easements? And the answer is the county very well recognizes that that is the law. The problem is that we've apparently failed to communicate very clearly that the county does not have the authority to recognize that the prescriptive right exists, and the county does not have the right to enforce the prescriptive right. So in this example, if a building permit is issued that depends on access across someone else's property and they block it, the county has no mechanism to adjudicate that problem. Those are things that only the court can do. But the answer to the question is the county certainly recognizes the doctrine.
Right. The county has never said that prescriptive access is illegal. The county is just acknowledging that what you may think is prescriptive access, your neighbor may not, and ultimately the only entity that can determine that is a court. Any other questions?
Just one. Clearly, the county has the ability to interpret or write or rewrite the existing, I guess, Title 17 document. But we also have an obligation to meet Chapter 810 regarding the roads and the status of those roads when people try to build on them. How do these two relate? How do these two processes relate? If we fix one and still have the other that we're under statutory obligation, what exactly are we conveying to people?
Well, the county's fire life safety regulations are codified as certified by the state. The state has minimum regulations that apply to access and other issues, for example, the driveway slope issue we were discussing before. Currently, the only affected activities under our code that would potentially require complying with fire safe regs are pulling a builder permit that goes beyond the existing scope of what's there. That's the issue that the Attorney General addressed. That's the issue I was referring to earlier, where I think it's fairly safe to say that any parcel that existed pre-1991 is exempt from those regulations. I do think that the board has some limited policy discretion on further defining those regulations, similar to what other counties have done, to the effect that there are some county-certified regulations that exempt all building permits from current fire life safety regs. There's enough ambiguity in the law that you could probably take that position. Our regulations currently are silent on that particular issue. There are also portions of our regulations that do offer modifications and waivers from those particular regulations that could apply in some situations.
Thank you.
Janice, okay, I understand about parcels created pre-1991 being exempt from the road standard under 4290. Or the Attorney General or whomever. But that doesn't apply then, as we're finding out, to driveways. Only the road.
Driveways are covered in a different area of the state regulations That particular issue has to do with the fact that there's a regulation that says driveway slopes shall not be over 16% in the state regulations.
But that's post-1991.
It's all the regulations are post-1991. What's at issue is what activities are exempt from those post-1991 regulations. And that's where there is a grandfather clause in the state statute that required adoption of the regulations. There's also language in the regulations themselves that exempt, quote, existing roads, facilities, and structures, etc. What I'm saying is that I think those exemptions speak for themselves, that they're not vague and ambiguous. The Attorney General opinion felt that they were somewhat vague and ambiguous and went and limited those exemptions. So what I'm saying is that if you have a parcel that was created prior to 1991, under this interpretation, you would be exempt from Chapter 810.
But that is not what the Attorney General opinion
That's
says.
not what the Attorney General has decided. They do acknowledge some exemptions, but they require you to have a condition of approval on your map pre-1991 that addressed the driveways, the roads, etc., in order to be exempt. And there's been no litigation or any case law on that particular issue.
Right, and that opinion was written about 15 years ago,
That
right?
opinion was written in 1992 on a request from Amador County, who in fact has certified regulations that don't agree with that Attorney General opinion. So it's an unresolved issue.
Okay, thank you. Okay, are there any more board questions of staff before we move to voicing our opinions on this subject?
Before Janice goes away, Janice, you asked for this, the page out of the general plan that goal 2-15 and the 4 bullet points at the bottom there. I'm just curious about whether the last bullet point where it says that you should be permitted to build a house unless, the bottom one says no known health or safety hazards exist on the parcel. Could that be stretched to include adequate and safe access?
That's strictly an interpretation by the board. If the board considers access a health or safety hazard to getting to the parcel, I would say that's a board interpretation you could make.
It says on, but okay. Thank you.
Okay, I believe there's one more comment from the public before moving back to the board's comments.
I would like to know, there's a Mr. Walker at the end of my road that's doing, I guess, a very sizable addition on his house. How come he didn't have to go through this road issue when he got his permit to do so?
Do you want me to answer questions?
I'm not, well, I think this would be better discussed in the department context rather than this.
Well, who do I talk to about problems that I'm having? Because everywhere I go, I get a closed door and
Well, you would have the building department and the planning department, depending on which
I've been
side
there.
it's-
What I'm saying is there some sort of a state or a county overseer that's supposed to hear problems that are, I could tell you, I'll sit here for a mile and sit here and talk, but, I've got a bunch of neighbors trespassing through my property. I pulled 2 permits to put on 2 metal buildings, and I've got shut down in the middle of one of them. I'm trying to build a house I haven't been able to get a permit for. It's been kind of a nightmare.
As I understand it, this case is in litigation, and it appears that a higher authority is already being sought.
Well, I'm kind of having the feeling that I'm not going to get anywhere until this thing gets through litigation because, like you said, that higher authority, which is my neighbor Wainwright, seems to have some long hands.
No, the authority is the court that you sought remedy from.
Anyway, I guess I'm not going to get anywhere. Thank you.
Stop it. Okay.
Everyone's going to talk again.
We've already heard from the people in this audience and do want to get to the board discussion. If you've got things that have not been said, go ahead, but I'd like to come to a close on the public hearing so that we can make some decisions.
I just wanted to respond to something that Janice Elliott mentioned, which of course was after the public had an opportunity to speak.
Okay.
I think one huge thing that Janice said, and I would welcome getting together with her on this and looking at this, because I have always understood that you can overburden an easement, and the prescriptive easement is defined at the time that you establish it. But I guess I've never heard the interpretation that if you buy a vacant piece of land and you go out to it for 5 years and you recreate on it, you fish on it, you shoot on it, you graze goats on it, that's all you have a right to do under your prescriptive easement. Now, I understand if you have a house on it and you want to build a subdivision on it, that's going to exceed the scope of your prescriptive easement. But I can't imagine that all the people that own vacant land in this county are now in a situation where they can't prove prescription beyond coming out to look at their trees or walk on their property. That to build a residential facility exceeds the scope of the easement.
Chris, you will go to court and a judge will decide that. We cannot decide that.
No,
Okay?
I understand, and that's quite true.
So
I mean,
we don't have to
you
argue
all
that
don't
point.
have the authority to do that.
We don't have the authority to decide that.
No, but misconceptions about this, I mean, this is a lot of hard times for the people who have to fight these battles in court.
I still got my 2.5 minutes, and I just want to characterize the. I just want that section 215 was characterized as a non-conforming use, and in fact that's section 222, which Diane was referring to, and I just want to make sure that you know that this does not have any non-conforming thing. This is about as simple as it gets. And this is the general plan, and we're talking about revising the zoning codes. If you want to keep the zoning codes where they are, then you have to do a general plan amendment to get to make that conform. So the general plan is the one to change the zoning code. It's simpler than doing, or in the next general plan as it comes up, eliminate this provision if that's the will of the people. Thanks.
Thank you.
Mr. Chair, if I could just respond to Mr. Williams' concern, I just want to make sure you know that the recommendation that we've set forth would make that issue moot about whether or not you're overburdening the easement for residential use. We're recommending that we allow, that we remove the legal access requirement for pulling a building permit for a residence, a primary residence. All
right. Before we move into the board discussion, do you want to summarize the recommendations that the department has put before us? And we will now, at that point, discuss the topic.
Our department is recommending that the board change their policy on requirement of legal access, and in doing so, change the legal code so that we can legally not require it at time of building permit application for certain types of uses. Those being primary and residential structures, primary or accessory single-family residential dwelling, including the respective attached or detached residential garage, and all permits for a septic system or other improvements required in order to receive a certificate of occupancy. So we understand that this is a policy issue, and we're asking you to change your policy and the codes to allow us to implement it, to allow people to pull building permit for a single-family dwelling, primary or secondary, on their property without showing proof of legal access. We're also asking that you recognize there are larger issues that need to be addressed, and that this is considered an interim measure, and that we're asking that a committee be officially convened by the board. It would be a Brown Act committee as an official committee of the board that would address and come back to the board with any remaining issues relative to agribusiness and other types of issues that are still out there. General plan, whether the language in the general plan, those types of things. So if you agree with our recommendation, you would approve an initiation to amend Title 17 so that we can take it back to the Planning Commission for a public hearing. And you would direct the other bullets to be done by the respective staff.
Okay. We've heard from members of the public. We've heard the recommendations of the department. Board, what is your pleasure?
Let me, if I may, give my comments. They're they'll be relatively brief. I strongly disagree with the recommendation of staff. I think it's an absolute total collapse on a public health and safety issue. I agree with what the board did in 1986. I'm a strong proponent. And let me just read that language. Each use of land or a structure shall have legal access from the nearest public road. Such access shall be constructed to the standards of the Department of Public Works for the land use proposed. If we're not going to hold to that, then the question becomes, why do we even have road ordinances to address it? The question becomes, then, well, how do you define a legal access? And we have done that basically using state code. State code defines legal access as, quote, recorded deed, parcel, or final map, or court order, close quote. Court order basically being anything to do with prescriptive or something that is in dispute. The board had a study session earlier, and there was a consensus by the board, of which I still stand by, making basically 3 exceptions to that standard. The first being permits to remodel, repair, or replace an existing structure or improvement, so that if your house burns down or your structure burns down, you have a right to replace it. Secondly, permits for earthwork related to fire protection and site clearing operations, agriculture and livestock activities, erosion and sediment control, drainage improvements, and other purposes. I define in this agricultural activities to include wineries. I do not include having general public access to the wineries or tasting rooms, etc. But if it's agricultural, and this says agricultural activities, to me that includes basically having paid employees grow grapes in vineyards and to have a winery. The third exception was permits for the construction of a new well not associated with any new residential use of the land or structure. So I'm for the definition of 1986. I'm for the current state code that defines legal access, and I am for these 3 exemptions to the rule. We have people that have had these problems. One's Arola Road, and they're working very hard to resolve their problems. I think a lot of the problems can be resolved through negotiations. That doesn't mean they're going to be cost-free. Basically, to me, it's a basic entitlement to make sure that you have legal access before you build on your property. The simple reality is, in our country, there's probably 60 or 70% of a family's net worth is tied up in the house and the parcel upon which that house is placed. And, you know, to basically say, well, let's just take 60 or 70% of a family's net worth and let's not require legal access and let's not require roads to county standards. And let's see what the next Attorney General's opinion comes out, quite frankly. And if you look what's happening in today's environment, particularly with the fires down south and the fires everywhere, the interpretations are going to become narrower, not broader. I think we're doing a great disservice to people to say, you know, take these horribly inferior situations and tie up 60 or 70% of your family's net worth, and either this board or a future board or the state is going to at some point come in and say you're going to have to meet these standards, and it's going to put your basically your whole net worth at risk. And I don't think it makes any sense at all for the county to accommodate that. I don't think it's in the public interest. I don't think it's in the public health and safety interest. I don't think it's in the fire and life safety codes interest. So I think we clearly should require legal access as defined by the state with roads to county standards with the 3 basic exemptions. And it's either the public coming onto a property or it's a residence that will cause these problems. And once you put a residence on a piece of property, you change the entire nature of that piece of property from agricultural or whatever it was prior to that residence being placed there. So that's my position.
Mr. Chairman, if I could clarify something before the rest of the board comments so that there's not a misconception. By agricultural activities, we're referring to production of agriculture. So a winery that produces wine would possibly be exempt. but a winery that provides tasting facilities, public
That's not
events
exempt. I said
is
not open to the
exempt.
public.
Right.
and
So I
not a
just wanted to
residence.
make sure that
It's
there-
just
we didn't
doing
have an-
agricultural
Right.
activities.
Okay. Are there other comments from the board?
Okay. I agree with Supervisor Tryon on legal access. So but that's just for legal access. Because what we're going to be saying on an interim process, that if you get in with a building permit under the next 6 months or whatever time frame we put, you're going to get it, but after that, you're not. And it's either required or it's not required. It's in our code that you have legal access. I mean, I think there was a mixed opinion here from the comments that we heard on whether you should be able to cross property or not cross property. I want there to be legal access on any new dwelling, on the replacement and so forth that Tom spoke about. I'm supportive of that. In terms of developing the road, I'm willing to wait the 6 to 9 months or a year. I'm not willing to wait a year. That we come up with a solution on that one. I like the idea of putting a sunset clause in. I'd like to see a 6-month one. I don't have a problem with the committee. I would like it in 60 days versus 90 days. I would like there to be 2 title companies, insurance companies, not 1. I would like 1 insurance company, somebody who insures property, versus title insurance, like a State Farm or Farmers. Or I do not support having each supervisor pick someone. Just, leave it at that. I think we need to have people on this committee who are involved in some way with this situation, and who are skilled in the topic. So these are my comments on what I support and don't support.
Bill, then Russ.
Okay. Well, with all due respect to Supervisor Tryon's comment about legal access, I do believe that it is very important. It's essentially important. But I am in support of staff's recommendation here. Not only because, but several reasons actually. If I understand the legal ramifications here, this is a policy decision. In other words, it's a policy that Calaveras County and other counties have actually come up with. There is, according to one evaluation here, there's no statutory or other legal requirement that there be proof of legal access for building permits for a use that is consistent with the zoning code. And I think we see that even in our own general plan. However, this county, for whatever reason, and I think it was a good idea to pass a statute that ultimately does require legal access, because we're just headed down a road that's going to be a dead-end road if we don't do something of that nature. However, that statute was passed several years ago, a couple of decades ago, and I just believe that we need a rather soft landing here, because I also believe that the county has some complicity here. Whether, for whatever reason, if they did not correctly enforce that provision, I'm of the opinion that people became familiar with the idea that it was not required. I can't expect that every citizen in this county, or every citizen that moves here, is going to have an intimate knowledge of our codes. You go on what common practice or social acceptance of activities are. And so for years and years and years, that has not been an issue that's been brought up, whether it was lack of enforcement or lack of understanding of the code or whatever the reason is. So at this point, I don't think it's fair to just slam the door shut without giving people opportunity to maneuver. That's one of the reasons that I agree with the idea of this committee, the committee to come up with some solutions. And the committee is going to have to, at some point, have some access to legal opinions. And so hope that gets built into there somewhere. And as Supervisor Tryon said, you know, people have 60 to 70% of their net worth involved in their primary residence. Well, a lot of those folks have intentions of having a primary residence in which they have 60 to 70% of their net worth in, and maybe they've only got 20 to 30% of their net worth invested in the property that they intend to do that. And I can tell you just my personal knowledge, just knowing of friends and colleagues in this county who have purchased property waiting to pay it off so that they could build their home. And it maybe took them 5 or 10 years to pay the property off. Now that it's paid off, they can go ahead and get their building permit and build their home, where they will have most of their net worth involved and invested. And at this point, to be told they cannot do that, you know, I don't think that's playing with a level playing field. From what I've heard here today, it's, I mean, we're about half and half of just the people in this room. People that want the door slammed shut right now on the legal access unit issue, and some others that feel that they haven't been dealt from the top of the deck. And so I like to deal from the top of the deck. I would like to see this worked out if possible. 60 to 90 days is not that long of a time to see what we can come up with in the area of compromise. From what we've heard today also, at least from what I've heard today, the codes and statutes, be they state or local, are somewhat nebulous and hard to understand, and so there needs to be some justification there. We're talking about the definition of legal access as it applies to building permits specifically in the issue that's before us today. So the idea of prescriptive easements is still somewhat nebulous after an hour and some discussion here to me. So that particular access, just by example, needs to be, if I'm understanding correctly, perfected by a court. How many people in the room know exactly what that would entail? I certainly don't. So I don't know if that was, oh, Bill, you know everything. Keep your hand down. Seriously, folks, I don't know what that would take. And I don't know that if you had to do this, you would see this as a great obstacle or something that amounts to filling out a couple of papers, submitting it to the court, and getting it back. It could be monumental. It could be practically nothing. So, well, just to summarize and not go on any more than I need to, I do support the recommendations of staff, including the creation of a committee to see if there's some common ground here that can be resolved. There are too many legal issues here that have not been decided. In my mind today, in the interim, we have people out there waiting with their pen in the inkwell, seeing if they're going in their checkbook, seeing if they're going to get a building permit or not. I also support the proposed language for temporary amendment to the zoning code so that the building department doesn't have to just go on vacation for the next 6 or 9 months. But we need to have a sunset clause there so that we know this is an interim measure and that it'll come back to the board for a permanent solution.
Steve,
Yes.
I need to get a clarification. If we omit legal access, whether we do it for 2 weeks, 2 months, 2 years, or forever, and you then want to cross my property to build your house, you can do that? I mean, that's where I'm a little fuzzy.
You can't just do it, but the county has no say in it. The county is going to issue you a building permit whether you have any access or not. Because
I would have to agree with that. You'd be on your own in terms of whether the access is enforceable or not.
But we're going to issue a building permit, period, because we're not going to look at legal access, which to me is insanity. That's just insanity.
Well, I don't know if it's insanity, but I agree that it's not a good policy, Tom, but it's what we've been doing for 20 years here, so another couple of months I don't think it's going to turn us upside down.
We have a whole litany of problems as a consequence of it.
Before we go from policy to pathology, I'd like to complete the round of first comments, and then we can go into our debate. Russ?
Didn't we recently hire a fairly competent psychiatrist?
He's booked, Russ.
We can call him.
If you're listening, come on down.
There's a button under your chair you can push.
We learned about that last week.
I was convinced that the proposed language was good after attending some sessions on this. I'd like to see that the 17.04.030 changed to read the way that the CDA has proposed it. I was even more convinced after seeing this thing pulled in from the general plan here. I mean, we had a long session last week about the need to keep the economy going in the county, and I mean, this is really quite powerful language here about here's a goal, and the purpose of the goal is to protect the reasonable use of property in the county. And it goes on to say to allow the construction of one single-family residence on each legally created parcel capable of supporting such a use. And that's pretty clear and concise to me. I think to do otherwise would be, in my mind, a taking. Granted, there are some people in this room, some, or at least one sitting up here that has a different interpretation. But I will vote to support the proposed language. I'm not sure exactly where I stand on the sunset clause and stuff, but I'd like to hear a motion. So, go ahead, Mr. Chairman.
Well, this is a mighty fine mess we find ourselves in. And I don't think we got here, I don't think anybody in this room would have gotten there of their own volition. I think there are a lot of people and a lot of statutes, there are a lot of attorney generals and a lot of people who weighed in on this to create this level of conflict and confusion. Here's a couple of things I know for sure. We've got choices between two property right extremes. On the one hand, it's to do what you think you ought to be able to do with the land you own. And the other is to have some integrity to the land you own and not have people passing through that you don't feel have the legal right to do so. Those are two pretty fundamental questions that seem to come into daily conflict these days in District 2. And I want to be clear that in my view, there are really different circumstances in different parts of this county. There are some counties with the roads pretty well in shape. You know, they meet county standard, and if you've got land along one of those roads or access to one of those roads, you're in pretty darn good shape, even with the current confusion. On the other hand, up country, there have been a lot of handshake agreements over a long period of time, many generations. They started with wagon trains and wagon trails and became driveways, which got attached to other driveways on a handshake and a favor or a pass on through a second, third, fourth generation. And what we have today is a real witch's brew of conflicting entitlements and sense of rights, which we have done little as a county to clarify. In fact, our own documents would appear to be in some contradiction, and our practices seem to have contradicted the documents, which has led a lot of people in this room to have righteous indignation when they thought that in the last year or two we changed policies, we changed documents. No, we didn't. We discovered what was on the books and actually tried to figure out what that meant. The sad thing about this is that if we, in fact, as Bill said, and I think that that's, in my view, his words were instructive in this, if we had something to do with getting into this problem, then we owe it to the people, all of us who now find ourselves in the midst of it, we owe it to try to help get this done. Now, Supervisor Tryon says that he thinks, and I agree with him, that when we do rural sprawl, when we build in places that don't have water, sewer, and roads, that makes for a pretty messed up place. And we've seen that happen in a whole lot of other parts of California, and I think it makes sense for us to try to have a better plan than that as our final destiny. But I don't think it helps us to get amnesia about how we got to this moment. We have decided already as a board that henceforth we're not going to be subdividing in places that can't sustain it. That includes roads, water, and sewer, and it includes observing the property rights of people that come in front of that subdivision. But our question today has a lot more to do with what do we do about this history? And my view is as follows. Number one, what happened before 1991 actually does matter, that there's something, clearly different before that we should at least pay some mind to. So in my view, it's hard to go retroactive before that. If there was a legal subdivision, if there was a legal parcel created, it's very hard to delegalize it after the fact. However, there were a number of things that happened between 1991 and the present, obviously, in this county. And that, to me, is really the scope of what we need to address. I'm in agreement with the interim proposal so that we don't bollocks ourselves up any further immediately that the CDA has come to us with. But I have a couple of other things, and I support the idea of a committee that can work on a deeper level because I'm convinced that no one of us here has a full picture of what's going on out there because each of our districts is so different. And this committee's task would really need to, and its composition would need to be geographically, and I suppose in regards to interests, diverse. That said, I think that we're going to need to not only talk about what our new Title 17 would look like and how to reconcile it with our roads and our future of trying to have a sensible future development, but I also think it needs to talk about process. It's not good enough to tell Mr. Borgadellin and his neighbors to go sue each other and fight it out. If we created their issue, we owe it to try to facilitate resolutions. Now, that won't always happen. It requires reasonable people on both sides. And as I understand it, what's happening on a roll of road, eventually, after a considerable, maybe I'm jinxing it here, but I think that the attempt for people to come together and work out a neighborly agreement is a whole lot better than making attorneys wealthy after neighbors disintegrate the threads that hold them together. And I'm finding this to be true. Road after road in my district has been invited to go to court, and I think the net result is not better neighborhoods. It may ultimately mean better roads or, some kind of court-ordered understanding. But in my view, the long-term relationships in my district are being degraded dramatically. And this is a pretty darn good county, and with a lot of good neighbor history, a lot of generations that seem to do quite well up to this moment. Maybe we've had a few Hatfields and McCoys, but in my view, we owe it to people to get better information about what is and is not a prescriptive easement out, so that we're not having unnecessary conflict. So that would be a good start. It would, for people to be able to come in to this county and get a fact sheet would be a nice start. Secondly, when people at least agree on the history and facts but still have a disagreement about what to happen, I believe there ought to be some form of community boards or mediation that gets people together and at least tries to resolve it. And then and only then should we go and tell people, sorry, you're unreasonable, you can't get along, go to court. But as a first step in our process, I find that to be wholly unacceptable, and I find it to be particularly damaging in my district. So I would hope that we'd find a way to get more process. And no offense to lawyers in the room, but you're a last resort, not the first place we ought to go. And it's true that people are making good money off it, but it's not improving the general economy and welfare of the people. It is actually sucking the what's left of economy into rather narrow hands. So my hope is that this committee will not only deal with the statutory general plan and title and code issues, and try to reconcile somehow to Attorney General's opinions, but we'll also try to address the process of how we handle these questions and what kind of information we can assist the public in acquiring. But as regards the issues before us, I support the second proposal in the staff measure, or staff recommendations. I believe that we should have a committee. I'd like to see it come back within 90 days. I don't want a long, drawn-out process here. I want to bring it back with recommendations for action. If we are to do something in the way, I think this is a good interim thing. I do believe that we should not have a permanent interim arrangement, so I do believe we should have some sunset date on this to try to force us into a comprehensive resolution of this within this year. So I suppose some form of sunset. I'd rather, instead of a sunset clause, I'd rather just say a date certain that this will come back to the board for final action after adopting this interim.
But we put the date in the...
No, you need a sunset clause, because otherwise the date gets pushed off and nothing happens. That forces it.
Clarification, are you talking about a sunset clause for the code adoption language, or just a deadline for us to come back?
For this interim solution that your office is recommending, and if the sunset set date comes and the board hasn't made any other changes, then it will revolt is a good word, huh? Resort to the current...
Revert, I believe this is the word.
Revert, thank you. Revert to the current statute.
The current... Okay, my understanding is the current statute is going to stay in place while we do the Title 17 revisions.
Right.
That we will accept building permit applications we won't be able to actually issue until the code changes, unless you give us direction otherwise. But that if we're bringing forth a code change, that's not an interim solution unless you put a sunset clause in it. So if you're asking us to adopt an interim policy instead of amending Title 17, that's a different recommendation that we need to know now.
All right.
I think that's the recommendation as far as I...
Well,
that's not. I heard that you were accepting. 3 of you were accepting our recommendation. Our recommendation is to amend Title 17. That's why I asked for clarification on the sunset code.
That's right.
Okay. So what we would do then is, if that motion is successful, is take Title 17 to Planning Commission for review, and we would identify one of the options would be to make it a sunset clause in the code language, much as they do with the state legislature, for consideration by the Planning Commission and the board when it comes back. Would that be sufficient?
And that sunset clause is going to say what?
That it could just be a recommendation that the code would be implemented
in effect until a certain date.
Effective until a certain date. It'd be up to you to plug in the fill in the blank.
What happens when that date arrives and the board has not acted?
It reverts.
Well, no. If
you've changed it.
If the board hasn't acted, the sunset date hasn't been implemented. Our intent would be we'd come back with the code changes.
Date.
And that gets back to my earlier comment.
Right. So it's a difference between a deadline and a sunset. We're planning on taking this back to Planning Commission in the next month. So the public hearing will be there in the next month. At that time, there will be recommendation. We can throw something out for, I heard 6 to 9 months. I heard a year. We can put something in there, see how the Planning Commission reacts to it.
But if it's a sunset, then it has to revert to something. So
no, or it just goes away.
Huh?
It can just go away. We're recommending that there...
You can't just have it go away and then we don't have anything at all.
Well,
no,
that's an option.
the amendments would go away. The language is already in the code, and we're supplanting it with amendments, so then it would revert back to the previous language if it's written that way. So
right,
in other words, legal access, you could say when you adopt it that legal access is not required for residential structures until December of 2010. And at that time,
then it would revert back
to
what the current code says.
Yes, that's one option available to you. It gives people time to pull building permits on existing parcels. The other option is that you just adopt the code, and then at such time that the board decides to change it, we do another resolution of intention to change it.
But that'll never happen then.
Well, I'm seeking some board consensus on this, and these differences appear to be rather narrow, but I'd like to catch people's opinion on exactly how to frame the recommendations that have come before us and appear to have majority support. There are several issues that I've heard. One has to do with the time for the committee to report back. I'm going to take the easy things first. We have, Marita has suggested 60 days. I mentioned 90. What is your sense of the capability of getting this committee up and running, meeting intensively, and coming back at an early date?
I assume the board is going to want to approve the content of the committee because it's reporting to you. Therefore, and we would have to advertise and let people put their names in, bring it back to you. That's going to take a minimum of 3 to 4 weeks to get it back to you. So if you want to say 60 days from the time of constitution, that might be sufficient.
60 days from the time of appointment.
Of appointment.
60 days.
No, I would say 60 days from the time we implement the interim solutions.
Even I won't go for that, Tom.
Why?
Because, I mean, if we're going to
It's
advertise...
going to take 30 days to get the committee.
So they can
Okay,
still...
let me just say, because I didn't speak to the committee, I think it's nuts to do this committee. The issues are very clear, and they're very simple. I mean, do you want legal access? Do you want roads to county standard? If not, then then we don't do it. I don't know how you form a committee of all these people to meet and decide something so simple. I mean, the issues are all out there. They've all been expressed. We have all the data and all the knowledge. I think, instead of playing football with it and punting, I think the board needs to make a decision. I mean, hold community meetings if you like. I mean, do whatever you like. But I don't think there's new information to be gained here. So I don't understand why we're just dragging this out indefinitely with another citizens committee that sort of goes on and on.
Other comments on the committee issue, both in terms of the timing of its constitution and its report back, as well as whether to have it or not?
Well, I remain in favor of it. I think it should be, if you're going to put a time limit on it, I think it should be from the time the committee is constituted. We don't know how long that will take. So I would support the 60 days, but only after the committee has an opportunity to be identified.
Okay, Russ?
I'm in favor of the 60 days after the formation of the committee. Formation and approval of the makeup, I guess.
Yeah.
Yeah. Yes. Well, I mean, I just have to say I have some very mixed feelings about this. I mean, I agree with Tom. I mean, it's another committee. The issues are really clear. Either we're going to require legal access or we're not going to require legal access. At this point, I am going to be voting against the proposed language because our code does say that you have to have legal access. And until this board, maybe through the committee, which is why I support it, says we do not think the county should have a requirement of legal access. You build at your own risk, and we have some mechanism to let people know through title companies or wherever that they build at their own risk and that they could have their property cut off, because I don't want it coming back to us. But which is why I'm sort of supporting experts in the field. Until then, I cannot, that's why I'm voting against it, because of A, not B, C, or D. So to get to Steve's question, 60 days for a committee to deal with something that the board really needs to have the courage to make a decision on.
And repeating something I said earlier, it's different in different districts, but for me, something new comes in every day, or at least every week. Whenever I go out into the field, I'm having new issues that I hadn't even imagined around legal access coming up. In my district, people are asking me, well, if I lug the lumber in across BLM land, built my house and on the property that I owned, do I have legal access? I've got people with airstrips on their ranches saying, is that legal access? I'm just sure there are things that didn't come up in this meeting and many other things that I would hope a team of experts would be able to evaluate and consider in relation to this. It's a more nuanced issue than a black and white version would be able to accommodate. So I also support the committee. I'd like to see it be constituted with people who are serious with backgrounds in this and are technical, have technical expertise. I would like it to be geographically diverse, and I would hope it would come back within 60 days of its constitution. I believe that's 4 members of the board instructing you on that. Now, as regards to A, B, and
regarding the composition of the committee, I heard Supervisor Callaway suggested some changes. Is the board in agreement with adding an insurance company representative on the committee?
Okay, let's poll
if you
that.
want to title insurance companies instead of one. If they're going to be talking about road standards, and I'm not sure that I heard that, but there was some discussion about that, we may want to include the building department and also a member of the fire community if they're going to be addressing those issues on there. And then whether or not you want, I had changed the recommendation to 5 public members if you want just 2. So we need to weigh in
all right.
on
Well,
those.
let's go through those one at a time. Personally, I feel it would be a cruel hoax to resolve one issue and then have people go back to square one on the road thing. So I'd like to see that integrated. So I'd like to see whether that's a board view or not.
I support that.
You want to eliminate
Yes, 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 yes.
You want it, what's your proposal?
That we integrate this committee's work with not just our Title 17, but also deal with the road issue.
Yes, you should do both at the same time.
All right, so we're unanimous in that. Secondly, we have the composition question, and let's just go one at a time. An insurance company representative.
Well, first you want to eliminate the 3 positions.
Eliminating the 3 positions, 2 supervisors and planning commissioner. What's the word on that?
Yes.
Yes.
Yes?
Yes.
Okay, that's 5. Now, adding Public Works. Any objection to adding Public Works on?
County surveyors representing Public Works, do you want an additional representative?
Well, I'd like to see a road, somebody.
Yeah, it's nice to
somebody
have a
who's-
road person there.
Okay.
Just can tell them the consequences of one-lane dirt roads.
All right?
Saves on overlay money, Don.
Okay.
Then we would like to have the building department also, the building official represented, and someone from fire, maybe fire chiefs.
All right. Any objection to the additions of those 2 in replacement of those? Everybody okay with that? All right. Any other suggestions for participation on this committee before we close that?
I don't think I heard about the insurance company representative, or whether or not we need 2 title insurance instead of 1.
Well, we have a title insurance already on it.
We already have 1.
And so we're talking about an insurance company that's got homeowners insurance as a
It does
business?
homeowners policy. I
Allstate
have
comes
one
to
other
mind.
recommendation. I think we
That's
should
the
have
one.
one representative from either the Cattlemen's Association or the Farm Bureau, because quite frankly, a lot of these
So you want an
issues
ag representative?
deal with going across agricultural lands. And I think it would be
How about
nice to
someone
have
from
a
the
representative.
Agricultural Dispute Resolution Committee?
No, I would like a member of the Farm Bureau or the Cattlemen's Association on the committee, not the Agricultural Dispute Resolution.
I thought they
We
sat
have a
on that.
representative of the Cattlemen's Association in the room. Do you think, could he make a comment about whether they would be willing to step up to this?
If you want to just appoint him today, he can start work.
Well, I thought it would be good to put him on the spot, Willie.
That's fine, a Farm Bureau representative.
All right. Any objection to that?
That's fine.
No, I'm
All
in
right.
favor of that. But I think that representative should coordinate with the Cattlemen's Association and the Wine Growers Alliance, and even Cal Grown, and represent
We'll make
the
that
agricultural
recommendation to
interests.
them.
Well, then we could approach the Ag Coalition and ask them to put a representative forward for the entire ag community, which I think would probably be the best way to go.
Well, then why don't you do the Farm Bureau, and then, what's the group you're referring to?
It's the Ag Coalition, it's the Farm Bureau, the Cattlemen's Association, the Wine Grape Growers, and Calaveras Grown. Combination.
That's fine.
Instead of Farm Bureau.
Yeah, so
An
they
Ag
just, so the
Coalition
Ag Coalition would be approached, and they would send
The
a
Farm Bureau
representative.
has the greatest membership and probably the most impact, because all the others just about belong to the Farm Bureau. So that's why I said the Farm Bureau.
If you
There's
leave
very
it to my
few cattlemen
discretion to
that
try
don't
to
belong
work
to
it
the
out
Farm
with
Bureau or
the
wine people.
respective committees. I'll try to work it out with the ag community.
Okay. They don't want to get too big.
The at-large public representatives, I had 2 on here.
That's fine.
No,
Why?
because I want people who have real vested interest or have skill knowledge in this area. And I think by expanding the group to what we have that covered. And if we do at large, it could be duplication.
We
and I
haven't
think-
represented the property owners specifically, or property rights groups, other than perhaps ag, although they're on both sides of the issue.
If you want more,
That's what my
I mean,
thought.
I look at ag, well, I look at ag as sort of being public also. You could put 2 ag people on.
No, let's just leave it as it is and drop the
Marita
two
wants one
out.
person from a gated community.
I do.
I really, I would heartily encourage you to at least leave 2 public members on there so that it doesn't look like we're trying to predetermine the focus of the committee, so that there is minority opinions allowed through public membership if they don't formally belong to one of the stakeholders that are mentioned. That's my only concern.
All right, well, let's see about the 2 members at large from the public. What's the opinion of the board? Let's poll it.
I'd rather see another ag person on it than just
Yes or
a
no,
member at
Tom?
large. Huh?
Yes
We're
or no
polling
at
on the
large?
question of the 2 recommended members at large. Yes.
That's going to give you 12. Is it okay to have they're not going to do any action?
That's fine.
Yeah, I'm fine with that.
No.
Did we cover the representative from the Fire Chiefs
Yes.
Association?
Yes, we did.
Okay, I'm okay with it, 2 at large then.
All right, so you have, on a 3
So
to
that
2,
comes out
you
to
have an
13.
at-large.
I would
seat.
like to just give full disclosure that County Counsel's office will not be providing legal opinions to the committee. County staff, if they need legal opinions, can ask through county staff, but it has caused some, and I think County Council can address this most, but I just want to make it clear, County Council will not be providing, you made a comment earlier about legal opinions, would not be providing legal opinions to the group, but would provide legal opinions to the board on the recommendations of the group, if that makes sense.
That does make sense, and while we're talking about the official aspects of this, it's my view that this would be a Brown Act committee.
Yes, it would be Brown
It's an official
Act.
committee of the board. It's subject to the Brown Act. It has to post, it has to have open meetings, and it has to post its agenda 72 hours before the...
Yes, and they'll keep minutes.
All right.
I'm not so sure that there's a blanket prohibition against my office giving legal. We take all those issues on a case-by-case basis. Typically, our time is reserved for board members and departments. I would agree with that, but I'm not sure that we're bound by absolute blanket.
I'm sure if there are legal questions that come up from within this committee, that we can find ways to get legal answers to them.
Yes, we're not intending to do that, but I was just responding to
There will be no attorneys sitting
there'll be
at
no
the meeting.
attorneys in the room.
I'm happy to agree with that one.
Yes.
I think that's what she was trying to
Unless they're an at-large member.
I believe that was the point. All right, we are now, now that we have a committee, and is there any, I think we've completed its composition. Are you clear on?
Yes, we're clear.
Okay. Now we move to a decision on the interim, what we're instructing staff on the interim measures that we've discussed. And I'd like to go down the list so that we can have each one polled, if that's acceptable to people. The first is to initiate the attached amendments to Title 17 zoning of the Calaveras County Code. Let's start with Russ and move this way.
Okay, the attached amendment being...
This is from the staff,
Yeah.
staff recommendations that we're...
This would be the
Right.
page that says existing language and proposed language, whereas
Right.
recommending an amendment to Title 17.
Okay, well, before I weigh in on this, is this sunset issue part of this discussion?
All
'Cause
right. Why don't we decide that first? I was thinking it would be better to get the content of it and then decide how long it should be, but we can go for the time first if you wish.
Well, the part about the sunset discussion that bothers me is that if we sunset it and we get right back in the pickle we're in, what have we accomplished?
It's meant as a sword of Damocles over our timing. That's what.
We would have honored Supervisor Tryon's request.
We're not in a pickle. What we're going to do is put ourselves in an even bigger pickle, because the pickle we're in is because we didn't do this.
Sweet or sour, Tom?
That'd be dill.
All right, well, let's end the pickle metaphors and get back to the question of whether we're going to have a sunset clause, and if so, when should that be, whatever we adopt here.
I am confused on what we'd be accomplishing by putting any kind of a sunset clause here.
I think Supervisor Tryon felt it was important to motivate us so that we don't find ourselves backsliding into the condition that we find ourselves in today, and that having some date certain for both the report to come back from committee and the board to take action on it might expedite us.
6 months.
Okay, that's not what I'm understanding by sunset. I apologize. What I'm understanding by sunset is that you would say that at a certain date and time you are going to start requiring legal access on every parcel, because the code would go, that the amendments would go away. That's what the sunset is.
That's right, but
So
the purpose of it is the motivation. I don't think any of us want to go back to the current status.
Of not requiring legal access? Or of
We do
requiring?
require. It is required, just hasn't been enforced.
Yeah.
Okay. So if the board already knows that it wants to require legal access at some future date, then that's the sunset date that you would put in these interim solutions. It gives the public time to go out and pull their building permits and activate their entitlements on the property, and then when the rule goes away, proof of legal access would once again be required. That's what the purpose of the sunset amendment would be for.
I think that keeps the pressure on the department, the committee, and the board to resolve this issue.
If that's the type of sunset you're talking about, I would like to see a 1 to 2 year sunset to give people time to be able to pull their building permits. This is not a good market right now. To get them in there to be able to pull their building permits and not lose their entitlements because they only have so many days or months to come up with the money and the funding to move forward with their building permits. So if you're talking about having the legal access requirement be put back in place at a certain date in the future, I'd rather have a longer period of time. That's different than getting it back to the board. This is talking about when it goes away again. I don't know if that's clear yet.
Yes, it is.
Okay.
Very clear.
Well, I think there are several different things we're talking about here, and we need to be clear on what we're voting on. The concept of a sunset clause that I'm talking about is the idea that we would have a group of experts reviewing our situation, coming back with a refined Title 17 and other things that would be amended, and in between, before that happens, before we've had a chance to thoroughly vet it, we would hold these interim measures in place. I'm not sure that and there's no definitive what happens at the end of that except what comes back from this committee and what this board does with it.
Okay,
now, that's different.
That's different.
That's right. And I want to be real clear on which it is that we're polling so that everybody knows what we're talking about. I don't mind polling both of those.
Okay.
But the question is which.
It was not our intent that this policy change would take effect immediately. It was our intent that the code would go back, we would start taking building permits, we'd get the code to the Planning Commission within 30 days, get it back to you hopefully within 60, and at that time the code would change, possibly have a sunset if you decide you want. If you would rather direct staff to suspend the enforcement of the code pending a final resolution of providing proof of legal access, that is a short-term deadline that would not afford as many people the possibility of resolving this issue before it went away.
Okay, is the board clear on the two different options? All right.
And if I could be clear that my recommendation is that we amend the county code and allow take away the requirement for proof of legal access either permanently or on a sunset clause. That is our recommendation for the primary and residential structures at least.
Well, that gets to the original question I asked. Initiate the attached amendments to Title 17 zoning of the Calaveras County Code.
Right.
All right, so why don't we poll on that question, and we'll get to the sunset clause after we figure out what it is we're talking about. All right? Everybody all right with that?
Yes.
Let's go with the first. I'll go down the list here. And if people want to, if we defeat one of these, we'll come up with an alternative which could include some of the suggestions in that previous discussion. The first is, do we take the recommendations of the Community Development Agency to initiate the attached amendments to Title 17 zoning of the Calaveras County Code?
Yes.
Okay. Yes?
No.
Yes.
Yes?
No.
Okay, 3-2. We have, secondly, allow the CDA to accept building permit applications for plan check pending final adoption of the amendment to Title 17. That's the interim between now and the adoption of Title 17.
That would allow people to apply for building permits immediately.
It's apply but not approve.
But they would not be approved until the board changed the code language unless you direct us otherwise.
All right.
I would support that if there's a sunset. If there is no sunset, I don't support that.
Okay.
The sunset would be when the Title 17 changes.
I have no problem with accepting the applications and proceeding as long as there's a sunset. But if the board, if this board, on Steve's next question, is that there is no sunset, it's just a change, then I'm going to vote no. So
Okay,
I guess
let me try to construct this sort of in a progressive fashion. We'll vote on each of the separates, but ultimately on the whole. And that people can take their, whatever gets a majority opinion on the content of each individual, we can move forward. And at the end, we will vote on the compilation, which would include or not include a sunset.
That confuses me now.
No? All right.
The second bullet
Let's
there,
try something else.
allow CDA to accept building permit applications for plan check pending final adoption of amendment to Title 17. I thought we just voted to approve the adoption of the amendment. That would be the sunset.
What?
That's what it says. Yeah,
No.
That item would go away when the board adopted the changes to Title 17. It would no
Yes.
longer be necessary.
Right,
Yes.
well, we've already voted to adopt the changes. So whatever time frame it takes to approve that
It would
is
go
when, that's when the
Yes,
sunset
it
is.
would automatically go away then.
So it's already built in. It is, that's what it says there.
No, but the amendments are on the next page, and the amendments don't require legal access, they don't require much of anything.
Initiate attached amendments to the Calaveras
The
County
attached
Code.
amendments are on,
We just voted 3-2 to do that.
not the next page, 2 pages back.
Yes, we just voted 3-2
Access
to do that.
requirements, proposed language, those
Yes,
are the
we
amendments.
just voted 3-2 to do that.
Right, but I don't believe we have actually voted a sunset in.
No, we have not voted a
We have
sunset.
voted that change to be implemented in due process. That apparently takes
would
in the
change the
neighborhood of
code.
60 days, and it would change the code.
It would change the code. So
And the
that-
question is whether we would sunset.
The sunset for this will be when we adopt whatever we adopt.
No.
Yeah.
That's not the sunset.
Yes.
No.
Bill Supervisor Cladino is correct.
That's not the sunset we're describing.
Right?
He's right. There's 2 separate.
Yeah, that's what it says.
All right, yes.
Well,
We're talking.
I don't view that as a sunset.
All right, we're
That's not-
talking
that's
about,
not
we're
a
using our
reversion or
terminology
something.
differently here, but
one's a
there are
deadline.
two.
That's not a
One's a
sunset.
deadline
That's not
and
a
one is a
sunset.
sunset. And
Yeah.
I'm talking about right now, we just approved the thing with the deadline, all right? But there is a sunset that has yet to be discussed, which is how long, once approved, that stays into effect after this committee comes back to us for further potential revision of that. That's a second, and that's what I'm referring to as the sunset. Is that clarified?
That's the sunset. This first
It
one just
accommodates
says
what
when
Bill
we
has
adopt
just said.
something that allows the plans to go
Okay.
forward, they will go forward.
If I could throw something out, and it'll probably put you on the hot seat a little, and if you don't want to answer it, that's fine. But if there are 3 of you that do not believe we should ever require legal access, then there's no need for a discussion of a sunset clause. If there are 3 of you that believe that we do have to have some form of legal access at some point in time, and you're just agreeing that this is an interim solution that will help us resolve that issue, then we can talk about the sunset. But otherwise, we don't even need to because we're coming back in with the code changes.
Yes, but we're going to go to that question at the end after we figure out what it is that may or may not be sunsetted. That's the process I've asked for. That's the process I'm hell-bent to finish, and we will move forward. Damn the torpedoes. Moving to allow the CDA to accept building permit applications for a plan check pending final adoption of amendment to Title 17. Can I see the nods on that?
No.
Yes.
Yes.
I can't answer it till we
Abstain.
answer.
Okay, that's fair.
I don't like to abstain.
Well,
this isn't an abstention.
What is it?
Then vote no. It's not an extension.
We would only accept them until the board changes the code. If the board takes 3 years to change the code, then they're not going to get approved during that time frame. If it takes 60 days, it'll get processed. They'll get processed. They'll be ready to issue as soon as the board adopts the code. That's what the intent of the recommendation
And if the board doesn't adopt the code,
then they don't get issued.
Then they don't get issued, and they spend a bunch of money, and we process them all, and oh boy.
But Tom,
we'll return the money if we don't.
We're only adopting the code if there's support on an interim basis, unless, as Stephanie said, 3 of the board members do not want to have any legal access omitted from the code, period. I'll just vote no because I can't.
That's fair enough.
No.
And Russ?
Well, I'm very much inclined to adopt this thing to allow the permits to be applied for, but it's really kind of paradoxical here. We've been very proud of ourselves recently about getting the turnaround time reduced to 6 or 8 weeks, and now we're likely to throw a bunch of them in 3 or 4 months holding pattern. It just, I just throw that out as an observation. But yes, I'd like to see the permits be accepted.
That's a 3-2. Now we have direct Public Works to compile a list of all former public roads that were removed from public maintenance but should still be available for public access, with the intent that the list be considered proof of legal access for parcels on listed roads for purposes of building permit issuance only, as there are no changes being recommended to Title 16 proof of legal access requirements for subdivisions. Can I see a show of hands on that? Russ?
I am in agreement with that.
Marita?
Again.
Depends on the...
It depends on the issue. If the property owner said, we want this road back and we don't want it for public access, and I addressed that earlier, which is, if I understood Stephanie correctly, it'll be on the list, and if the property owners still do not want it for public access, then it should not be required.
The only thing that will end up on the list ultimately is those those roads that county council has determined that there's remaining public use, even though the county maintenance has been abandoned. So we'd be asking them for a legal opinion if the county abandoned their public use or not.
Okay.
So
I don't want to get into, but we have lots of roads that we have issues that are ours, but that are not maintained.
We may be taking an order we can't fill here. This is I've been around the edges of this problem, and it's potentially a huge project. So with due respect, if this could be, before the board makes this as a direct order to my office, I'd like to be able to find out or quantify it.
Right, and I don't see Public Works in the room at the moment, which I find problematic as well.
Mr. Chairman, compromise, perhaps we want to recommend that the committee look at that and councils.
Well, my presumption was this was information that might help inform that committee on some of its work. This is a lot of the roads that are currently in conflict fall into this category, and knowing what their origins were and what their current status is.
So how about if we change the request to direct Public Works to compile a list of all roads that formerly were county or public maintained and no longer are? There's no legal interpretation of that, and then further research can be done by Public Works or us.
All right, at least we get the information the committee can work with.
We get the committee.
All right,
I don't see how you can operate off that, because you're basically saying we're removed from public maintenance, but should be still available for public access.
No, I'm saying take that out. I'm amending that recommendation Direct Public Works to compile a list of all former public roads that were removed from public maintenance.
Okay.
Period.
All right.
Then the question becomes, were they abandoned? And is that why if they're abandoned, that's different than if we retain a public interest, but they're not in the county-maintained system. We need to be very clear what we're defining.
We just put a period there. We're not defining anything. We're asking him to compile a list, and then we would ask for
You're not going to
legal.
act or issue permits based on
No.
Okay.
And a period at the end of maintenance, period.
Okay.
All right, so the amended recommendation will now be polled. Russ?
I agree.
Marita?
Yes.
Yes.
Yes?
Yes.
Okay, that's 5-0.
Woo-hoo. Must be getting late.
It's nice to, nice to
We don't know yet.
It's nice to see you three got one right.
Keep your day job, Tom. Not funny.
Moving right along, create an ad hoc legal access committee consisting of the following representation, and that was actually already discussed, and I believe we've concluded, but I'd like to see show of hands on that topic as amended by previous discussion. Russ?
I'm fine.
Yes.
Rita?
Yes.
Yes?
No.
Okay, that's a 4-1. I believe that concludes the response to the staff recommendations. Is there anything further that is needed in this meeting?
Well,
I'm hesitant to throw this out, but if there are
Access.
3 or more of you that would like legal access to become a future requirement for all building permits,
Sunset.
we need a sunset code. If you know that now, we'd rather include that in the recommendation to Planning Commission so we don't have to do this again
That's fine.
as soon as they
Pull
get
the
back
board.
to the board. So if the board is of a mind that legal access is something that should eventually be required and would like to see us put a sunset on these, on the amendments to the code, it would be nice to know that now. If you are of...
Well, I don't think that all of us are prepared to make that decision. The question is whether we want, there's 2 different reasons for a sunset clause. One might be that you want it to revert. Okay, somebody might vote for that purpose. Other people may want to vote for it for the purpose of getting this committee's work completed and this issue before the board for finalization within a certain time frame.
We would not put a sunset code on for that reason. It would just be in place until the board revised it, and then you would direct staff to bring it back
With
as a
all due
deadline.
respect to staff, we might want to do it for that reason, and that's for us to decide, and I believe there's at least some sentiment on this board to do that. Not for the reason you stated, but for the reason that we would state up here.
Okay. I just want you to know that if it doesn't come back for whatever reason, and it could be because somebody throws a CEQA issue up that we can't get it back, that we end up right back here again because you have a sunset provision in there. That's...
I'll take that risk.
similar to what happened with the Blue Mountain Residential.
We would stop issuing building permits again if it's sunsetted before the board made a decision. That's why typically a sunset clause is because you want the code to go away, not because you want staff to get back in time.
I don't know that for me, it's not that maybe I want it to go. I don't know. At the moment, I do not want it to go away. I might in 6 months or a year, depending on what the parameters might be. So I'd like to keep it open, and I'd also like to keep this board's feet to the fire and the committees and staffs, which is why I support having that sunset. I mean, so how I'm voting today could be different than how I might vote in 6 months.
I'm going to take this in 2 parts. One is whether to have a sunset on this, and the second is, if so, how long? All right? So, yes, Russ?
I just want to ask a quick question here. Am I to understand that the legal access component of this doesn't really apply to parcels that were created prior to 1991?
No. That had to do with the fire standards
The fire
on the
safety
roads.
stuff? Okay.
The policy issue before you has no date.
Okay.
Yeah, it's universal.
Yes.
Well, I would like to propose we have a sunset clause that's like at the end of 2008. But I'm not in favor of one that is shorter than that.
That what?
At least until the end of 2008.
Yeah, December 2008.
December 1st?
End of December.
Merry Christmas.
Since we probably don't meet that date.
No, just figuratively. End of the year.
Okay, what that means is that we will go to Planning Commission with these code amendments, and there'll be another section in there that says these code revisions shall expire as of December 31st, 2008. That's what that means.
That's fine. I mean, I go with that.
You can always amend that when it comes back to the board, but that's what that means, is that the interim solutions go away and we revert back to whatever is still in the books.
Thank you. I'll support that.
But the interim solutions would not go away. We're going to hopefully adopt the recommendations of this committee.
Not if you put a sunset clause in there. If you put a sunset clause in the code revisions go away, whether they're recommended by the committee, recommended by the board, whoever it is.
Well, then the board has to act.
Before the sunset occurs.
Yes, I mean, that's the whole
Otherwise, you
point
go
of it.
back to an untenable situation.
Right.
What's the correct situation?
I really don't want to keep, we appear to have hopped on a hamster wheel. We're running fast but getting nowhere, all right? My suggestion would be that we poll the board as I previously discussed. Do we want a sunset clause on this? If so, how long? Russ has already spoken. He says he'd like it if it is at least to the end of this year. Marita?
Yes, and I'll support that.
To the end of the year?
Yeah, I would support that, or even longer. I have to admit that I would like to see what if anything this committee comes up with. I feel like we're awash in information and starving for knowledge here. I really do, and it's not a comfortable feeling for me when there's no state requirement for us to have proof of legal access. It's a policy thing that this county came up with, and what bothers me is this rush sometimes that we get into. Sometimes it's appropriate, sometimes it's not, but I'm not sure which it is this time. We've had this in our codes for 22 years, and all of a sudden we have to decide here, right now, this moment. I want time for this committee to get together and research some of the issues that were not resolved today and come back to us. And like Marita, in 6 months, I may change my mind and I may support the absolute abolition of this or their affirmation of it. I don't know yet. So yes, my answer is yes, to the end of the year.
Tom?
I support a sunset clause, but I think waiting to the end of the year is too long. I would support something like 90 days after the committee is formed.
All right, and I would support at least to the end of the year and possibly further, but it appears that we have a majority for to the end of the year. We could extend if the reports and other things came in and dictated further work. We'll see, but I'll take it now as a majority support for the end of December as a sunset clause for the newly revised titles. It will be implemented with the sunset clause to the end of this year.
For the recommendations that we're going to take to the Planning Commission in 30 days, we'll have a recommendation that these revisions end December 31st, 2008, is what I'm hearing you say.
That's, I believe, is that correct, Board?
Yes.
Mm-hmm. Okay, and that would be a 4-to-1. Is there anything else to discuss? Is there consensus on, I believe we already expressed this, but I want to make sure that this group be commissioned to, in addition to what's been recommended, that we've amended that to include the road issue to be considered concurrently. I want to make sure.
By the committee.
Yes, by the committee, and I want to make sure that that's formally adopted by the board. We had head nods before.
We will revise our minute order and provide it to council and the board clerk's office for confirmation before it's submitted, and then you'll have opportunities to approve
All right, any wrap-up comments, Marita?
Yeah, Tom, you want 90 days after the 60 days, and we're going to have plenty
I
of...
said 90 days after the committee is formed.
Yeah. Oh, after the committee's formed? I thought I could get your vote. I said it only takes us to 8 months, and we have 9 months to go. It's okay, Tryon.
All right. Some of you have probably seen Sausage Made, and I guess there's something of that nature going on here, but I do believe we've made some progress, and we have a clarity of next steps. I do appreciate your patience in participating and hearing us out. This meeting is now adjourned.
Good Lord.